All right, happy Tuesday, everybody. It's Tuesday, so it's the Teaching Tuesday here at the Thompson Law Group World Headquarters. I am Brett Thompson, the hashtag Closing Ninja. This is the Closing Ninja Classroom. I think you know the deal. We got a really crazy seller side market. There's a lot of competing offers, escalation clauses, and whatnot. And I have gotten several questions in regards to the VA escape clause and the FHA amendatory clause. So around here in Hampton Roads, well, everywhere in the country, it's a federal law, but in our RAIN contract, if you're in Hampton Roads and you're a real estate agent, you're probably using the RAIN contract. There is a VA financing and a FHA HUD financing provision, and it says pretty much this. This is the VA financing. It is expressly agreed that notwithstanding any other provisions in this agreement, the buyer shall not incur any penalty by forfeiture of earnest money deposit or otherwise be obligated to complete the purchase of the property described by the agreement if the agreed purchase price or cost exceeds the reasonable value of the property established by the Veterans Administration. What does that mean? So that means if the appraisal comes in low, a VA buyer, okay, a veteran that's using a VA loan, can terminate the contract and get the deposit back, period. That cannot be waived, all right? You cannot waive that via contract either. So I have seen some attempts at waiving the provision. So I've seen some attempts where the parties will put in another provision in the contract saying that we agreed to pay, for example, $10,000 over the appraised value. Well, if you're dealing with a VA qualified buyer and the contract is contingent on VA financing, that provision means nothing, all right? So you cannot overcome the federal statute. So VA and FHA, these are federally backed mortgages, and there are certain underwriting provisions and requirements that go along with it. And the escape clause for VA is a requirement, and the amendatory clause for FHA is a requirement. And in both those instances, your FHA or your VA buyer can terminate the contract and get the deposit back. And you cannot overcome that via language in the contract. So you can't put in the contract, I'm going to pay X number of dollars over and above. You can't like preemptively waive the escape clause, all right? However, once the appraisal comes in, a VA buyer does have the option to move forward or not. So the additional language says, the buyer shall, however, have the privilege and the option of proceeding with the consummation of this agreement without regard to the amount of the reasonable value established by the Department of Veteran Affairs. So that means at the point in time when the appraisal comes in, the VA buyer has the option, all right, it's up to him or her, whether to terminate the contract and get the deposit back or move forward and pay the difference between the appraised value and the contract price. But it's up to the VA buyer at that time. So you cannot preemptively, when you sign the contract, just throw a provision in there, you know, saying, hey, we're just going to pay X number of dollars over and above. We're going to pay whatever. We're going to pay the purchase price regardless of what it comes in. You can't do that. I mean, you can try to do that, but it's of no legal force and effect. It's void. So VA escape clause, FHA financing, the amendatory clause. So just keep that in mind. I mean, this is a very seller-friendly market. There's a lot of competitive bids going out there. But if you're dealing with a buyer whose the contingency is FHA financing or VA financing, if the seller agrees to that, then they can get out. They can terminate the contract and they can get their deposit back if the appraisal comes in low, regardless of what other language is in the contract. Thanks a lot, guys. Happy Tuesday.